Yeah, good afternoon, everybody, and I hope you enjoyed your lunch. So what are we going to be looking at today? Basically, we're looking at GDPR. We all know GDPR came in effect, technically it's a year old now, or a year plus old. And we've been fortunate enough, that's my view, to be on the better side, so to speak, with the regulation. So what will happen when we leave the EU, whichever way? Would it be a no-deal scenario or with a deal? Which either way, we have to prepare for that. And what I will be looking at today is just to say what organizations are going to do in preparing for that. In a word to introduce myself, I've been around GDPR since when it started, I would say 2016. So the sad fact that in my household, GDPR have become the key word. I'll give you a story. I have 4 kids. My youngest one was 9 at that time. And she's got bags for different occasions where she goes to. And on this Sunday morning, we're going to church, and I heard her calling her mom, "Mom, where's my bag?" And the mom asked her, "Which bag?" She said, "The GDPR bag." So that tells you how GDPR have been in the last 3 years in my house. Let me just give a brief introduction myself. I've been around doing the DPOs. I think this should be my 4th or 5th roles. They call it Chief Privacy Officer for Nesta. We are a foundation charity. We help people develop their ideas, innovation, basically. So we've been sponsored by the government and a financial endowment. So if you have ideas in regard to how you want to better the aging population, for example, let Nesta, we go around, look for fund for you, and sponsor your idea. So that's basically what we do. Now back to what we're going to be talking about. So in the event that we leave without a no deal, the main issue is how we're going to transfer data. Is it still going to be the same thing that we are now, or do you need to put things in place? Do you start looking at how you're going to make sure you're going to be compliant with GDPR? Because the UK government actually, we're going to be keeping GDPR, we're going to embed into our own law. So even if you're getting data from European countries, you have to comply to GDPR. So GDPR is here to stay. We have to find one way or the other to go around it. So what it says that we'll become a third country. So it is not only GDPR, but if you look at all regulation across the PSD2, MiFID 2, and all that, because most of them are European regulations, we become a third country. And what that means is we will not be afforded that right of transferring data the way we do it currently. Okay, so organizations now need to take stock of what they need to do. Can I show of our hands if Brexit has been discussed in your organization when you transfer data? Oh, that's good. That's very, very, I'm really, really impressed about that. Yes, good. So for those that have not started, I think it's now time you start to discuss that, because it's going to come to you. So you have to decide on the appropriate measures you need to put in place to be able to transfer those data. Sending data across to Europe wouldn't be a problem. It's when the data is coming back that is what will be the problem. So you don't need to worry about the order. According to GDPR, the regulations gives us 3 or 4 options for you to transfer data across. The most popular one is going to be BCR. BCR is the bind to corporate rules. But however, you're not going to get it immediately. The last company that I worked for, because we're a multinational organization, we have 120 acquisitions, and she machines across the globe. But we didn't have a bind to corporate rules in place. And I went to the ICO, we want to start that process, and said it's going to take a minimum of 18 months. So if you're going to start that is the long term. You having that at the long term is going to be the best option for you to transfer data within your organization, even if you have kind of entities across Europe. The next one is going to be the most popular one people will use now is standard contractual clauses. In my experience, it's good for now if you don't have binding corporate rules, but in a way it's difficult as well. In the sense that if you have, in my case, I have 120 acquisitions. So each of those business units, you have to go around them for them to sign those clauses. So especially if you transfer your data to, for example, America, just me, you rolling out, I was rolling out Okta, for example. Okta is a multi-factor authentication software. Now we have to sign that contract among all the entities. The challenge is that who is going to sign it? Everybody will run away from it. They don't want to sign it. They don't want their name to be on it. And you DPOs in the house, if you come to the stage, you have to put your name on it, because if you want that process to go so fast, you have to put your name on it to say, yes, you've looked at the clauses. You don't need to write those clauses down. You don't need to write those contracts. It's already on the European Data Protection Board website. So you can download that contract, but you don't need to, you cannot change anything from it. You just need to put your name on it and put your activities, what you are transferring, what kind of data you're transferring, what kind of categories of data you're transferring. The code of certification and mechanisms, those ones are things in the article, what the article says you can put in place. I put in derogations there. I've had the discussions with a couple of people I want to go around, and somebody told me that they use derogation to process data to a third country. And I asked him, why do you do that? What is the reason for you doing that? He said, because that's just the most easiest way for it. That is absolutely wrong. If we look at the article, what it says, you cannot use a one-off. It should not be repetitive. So if you're going to be transferring data to, say, other countries, say America, for example, you can use derogations, or to third countries, you can use derogations, but you can only use it once, a one-off. It shouldn't be repetitive. Okay, so when we transfer this personal data from the UK to other jurisdictions, like I said, we can transfer those data to other jurisdictions, while we can use standard contractual clauses, like I've said there. We can just bind the corporate rules. So if you're transferring from the UK to America, for example, and the person you transfer, they sign up to the privacy shield, then you're technically in order, because they're already one of those mechanisms that I talked about in my previous slides. Organization with binding corporate rules now, I think you guys should be smiling, because technically, if we go without a deal, you are already in a good position to start your data transfer without putting any other technical measures in place. So in the event that we leave without a deal, what it is that, since we're becoming a third countries, we will now need to appoint what we call Article 27, it said you have to have a representative. I've seen a lot of companies contacting me that they can be a representative, especially from Ireland, Republic of Ireland, that they can act as a representative. So what that means is, if your business have footprint in, say, continental Europe, for example, you will need to find a representative. If you don't have those measures we've talked about before, you'll have to find a representative that will represent you in the EU. So technically what that means is the supervisory authority know who to go to in case you that's in a third country have come across, there's any issues with that. But I don't, in my view, I don't see how that will properly work. Yes, it could be on paper, because when somebody contacted me asking some few questions, I was not comfortable with what he was saying. A lot of law firms will want to use the legal connotation to say they can act as a representative. Okay, so like I said, the purpose there is for the supervisory authority to know who to go to, so that the data subject, if there's any argument or any issues in regard to subject access requests and things like that, they know who to go to, they know who to hold. Okay, so here the positions under the withdrawal agreement. So now if say we go with the deal, so the GDPR and related EU laws will still apply in the UK. So because the UK government have said we're going to embed GDPR, in fact, it has been embedded in the Data Protection Act of 2018. So we're still going to be working with GDPR. So the GDPR laws will still apply in the UK, and the UK laws, the EU laws as well. We tend to get adequacy decisions. We're hoping to get adequacy decisions. In my view, I don't think we should be applying for that. I think they should just give us automatically because we've been part of GDPR for years. It just shows you the bureaucracy in the EU. So because they're not setting now, they're going to give us the adequacy decisions. Adequacy decisions means if you granted adequacy decision, you don't need to put any other technical measures in place to transfer data. So you just go, as it used to be, what we call business as usual, just transfer your data. Okay. What about if we don't get those adequacy decisions? Well, we need to wait to see if that will happen immediately. Because of the bureaucracy of EU, I don't think it's going to happen immediately. I don't think it's going to happen in the next 2 years. That's my view if we go out without the deal. There's some setting acting around, speaking to some EU lawyers, privacy lawyers, what they found that the EU is going to hold, or the EU is going to hold against us, is mainly the change to our human right, because the conservatives are thinking they're going to scrap that Human Rights Act. And once that comes in, so meaning we're going against the EU regulations, and we're not going to get adequacy. Okay. Again, another one is the withdrawal from the Human Rights Convention. If that happens, we're not going to get immediate adequacy. It's going to take long for us to get it. Again, the last one is the surveillance law, which has been a bone of contention all along. During this GDPR period, it's been there, but because we are also already inside that GDPR, inside that process, they didn't take that seriously. But I think that's what they're going to hold against us. I was in a conference on Tuesday, and somebody was saying he thinks the EU is going to hold this as a bargaining chips, to say if we want to stay in the EU, then we have to abide by this rule. For me, if they want to do that, I would say we do the same to them as well. Like we're all here, we all have our own either leave or remain. So I don't want to go into that now. I appreciate those ones that they say they want to leave, and those that want to stay. We all have our own reason why we choose that. But if that's the case, if we leave without the deal, that is one of those issues we're going to be getting. So what our organization need to do, we need to be discussing this in the board, especially to those DPUs. At the end, I'm going to talk about the questions that you need to ask of your DPUs, and you DPUs that are here, or privacy officer, the questions you need to ask to your board to be able to be compliant with that. So if we say, well, there's a withdrawal agreement that have been, if it is agreed, so we'll see remain the same. There will be a transition period. What that means is everything will still be the same. You don't need to put any changes in place. So our Data Protection Act of 2018 will remain in place because they're already aligned with GDPR. UK businesses will also be able to continue to transfer data to other jurisdictions, either to America using the privacy shield. Okay. However, we'll need to review our policies again, our privacy policy, to reflect the current state. We'll need to speak to our suppliers, our contractors, to change. So this way your legal team will come in now to start looking at the legal contract that they already have, to reviewing the contract and making kind of a change, like an addendum, so to speak. Okay? So, like I said there at the end, it's either we have a deal or we don't have a deal. We need to be prepared for it. Basically, that's it, whichever way. So I remember when GDPR started at 2016, a lot of organizations, why you see a lot of organizations not getting close to compliance. The last survey that they did, I think it was about something like 58 organizations that's close to compliance with GDPR. Why was that? People thought GDPR would go away. People thought GDPR would not stay. People thought we're just going to find a way around it. In my view, there's no way around it. You have to be prepared. Now, it's better to be prepared and don't use it than not to be prepared and then start panicking and rushing to do those things. So I have a summary here of what I think organizations should do. What I would advise is, if you've not started at all, just the bare minimum, try to see that you have those binding corporate rules, have your international agreements, speak with your vendors, look at the area of, if you want to get a representative in your region, or you want to transfer your business, your main business activities into Europe, and then maybe use a standard contractor courses to bring the data back. So again, this is where I will ask the DPOs in the house. I think I saw a lot of hands raised earlier on that you started discussing with your board. So what I would say is that what you should look when you discussing that is to look at your data flow. So that's where your record of processing activity will come in now. Because if you remember, maybe you DPOs and other people, you didn't do that activities, but you were the one overlooking those activities. And you must have seen in your record of processing where you transfer data to. Now, like I say, the ball is in the other court now. So instead of us now looking at who we share our data with and what are those, if they're in Europe, now those people are going to be looking at us as a third country to make sure they are compliant with GDPR as well. So you're going to get an influx of reviewing of contracts. You're going to get a lot of standard contractual clauses that you need to sign. Okay. Again, have you had your third-party processing agreement? That is what you need to review again. I guess you've got DPOs and privacy officers. You do get all those documents come to your desk. So these are those kind of I'll call it extra duties that you would need to entail. You would need to now start to speak with all your team, especially your marketing team, to see what they have. You need to review your record of processing activities, how you process that, to make sure that it's, you say where your data is flowing to, looking at your retention period, and again, your corporate risk register that needs to be updated. Possibly your risk needs to change. Possibly maybe some processing activity you're doing before you put in at medium risk. Now possibly it might be a higher risk. So again, you have to review your risk. You need to be asking your risk officer or your chief risk officer if you have one. If you don't have one, I believe that will now fall on you as DPOs to now start reviewing that. Okay. You're looking at possibly said earlier on. Do you want to relocate to the EEA? That's something you should be asking your board as well, because cost is going to play a massive role in this as well. Okay, the budget, your budget will definitely rise because you will need to engage more people in terms of you to be compliant with GDPR, in the sense that you're dealing with the other 27 member states. Okay, and that key part is your workforce. How are they equipped for this new change? Have you done possibly training? I have training tomorrow to train my workforce in regard to not necessarily on Brexit, but it's on originally I was supposed to train them on GDPR and the process, what has gone so far in the last year plus. Now I've now need to update my slide to add the Brexit onto it. To be fair to you, we've not talked about that as well. So that is my starting point of start to discuss, because I've just been in this role for, I think about 6 or 8 weeks. So those are what I'm looking at now. This is just, what I put in here is just my line of thought, what I'm actually looking at. And I feel other DPOs will be in the same situation as well. Again, if you are not sitting in the legal team, you should certainly seek advice from your legal team. Looking at what kind of contract you have in place. What do you need to change? So it's not all panic, it's not all gloom and doom. There are things that we can do. It's only that when you're doing your standard contract process when you're transferring data into from the EU to the UK, you don't need to put extra resource. It depends on how large your organization is. You might be bombarded with a lot of those clauses. My last rule that I did, the standard contractual clauses I did, I had close to 68 to look at. And you have to look at the kind of record, the kind of processing they have. Because like you know, they will just send you that contract. Some people will just do it just like a tick box. They won't put it properly. There was one I reviewed, we're transferring sensitive data. But when I look at my processing activities and look at what was recorded on the standard contractual clauses, it was totally different. So it gives us, privacy officers, DPOs, extra work. You now have to review those processes properly. So whichever way we go, I think we will be fine. Either we remain, either we have a deal or we don't have a deal. I think we will be fine. There's always a way around everything. I like seeing the cup half full rather than half empty. If we have that mindset, I think we will achieve a lot. So originally what I wanted to make this presentation, I was told it's 20 minutes, so I prepared the slide for 20 minutes. So I think I'll just overgone over time, so I will want to leave that for more questions or discussions, and also certainly I want to get your own opinions as well. Because when we come to this kind of event, we don't just come here to see faces. We want to get ideas from people. We want to learn how people do things differently. I think I've been to a lot of these events. I've picked up one or two best practice, if I would use that word. I was once in a conference with the head of data protection, the DPO center, and we were aligned. Since then, I've been having discussions with him. I mean, it was kind of a free advice, so to speak, where I'm not too sure. So I would say we come here to exchange ideas. So I certainly want to hear from you and your ideas. Also, if you have contradiction with what I've said, I'm open to that. I'm open to change. Thank you all.
And we do have time for a couple of questions, if there are any burning questions. Oh.
There's one there, there's one there.
Excellent.
Hello. You mentioned a connection between the withdrawal from the European Court of Human Rights and the consequences for an adequacy decision. Is there any strict legal connection, or is that a political thing, do you think?
Well, I mean, I don't know, because I don't do politics. But I should think conservative in the House, you guys can answer that questions. Because I don't know, I don't do politics, I don't know the reason behind why they want to leave. I don't know why, because we've been in that for a very long time, so why do you want to leave? If not just for, maybe it might be political reason, but I don't have an answer to that, to be honest with you.
What I mean is, why would it have an impact on the adequacy?
It will have impact because we're talking about, look at what GDPR is created for the right and freedom of a data subject. So if you withdraw it, you're taking that right of that individual away. Especially that surveillance law as well will play a big role because not all the 27 member states agree with what we do in terms of surveillance. So they might bring that as a bargaining chip. That's what we're trying to say.
It's my understanding that there is a standard contractual clause that allows a controller to a processor, but not from a processor back to a controller in the UK. Is that correct? And if so,
No, I
what
didn't
do we
understand.
do?
Can you repeat the question again, please?
Sorry?
Can you repeat the question, please? I think I traced
Yeah,
it.
it's my understanding that there is a standard contractual clause. That I think there's 3. You said about their standard wordings, and you just drag and drop them.
Yeah.
But there is a gap between a processor that is based in the EU in this scenario coming back to the UK. Is that understanding correct? And if so, how would you work around that?
I think there's a lot of those standard constructor clauses on the EDB, the European Data Protection website. It's not just only contractor to contractor. You have contractor to processors, and you have processors to contractor as well. Controller, before I call contractor. So those scenarios are already to be taken care of. So you just need to pick the one that suits what you're trying to do.
Okay. And one more question.
I'd be interested in hearing your experience, if any, in dealing with your cloud service providers and trying to identify where data physically is located when you're using those kinds of services. And any tips you have there? Yeah,
I have. When I worked my previous company, like I said, we have 120 acquisitions, and most is an American company, and most of the servers are based in America. Most of the cloud providers are based in America. So the questions I always ask is, where is my instance of data? Where do you store my data? Do you store it inside the EU or outside the EU? So most of those big boys like the SAP, Microsoft, Salesforce, and the rest, they're already taking care of that in terms of where your data is stored. So they can tell you exactly where your data is stored. Like Google, for example, will tell you maybe it's stored in Ireland, maybe it's stored in France, for example. So I think those kind of issues, I don't see them as issue in terms of cloud providers, what they provide. They will always have where those that don't have places, then you now have to put in that contracted place.
I think I'd also just quickly add to that, check where they're holding their disaster recovery as well. So it's all permanent storage, not just current storage. Anyway, thank you, Harry. Thank you for that.
Yeah, 2 minutes to spare.
Yeah.
Thank you very much.